So for my Chapter 11 assignment, I had the Pregnancy Discrimination Act, and I apologize if this video goes a little bit long. I did find a really neat case study for this. But the Pregnancy Discrimination Act is an amendment to the Title VII of the Civil Rights Act of 1964. It's discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes to unlawful sex discrimination. This amendment, or this act, protects women, obviously because women and pregnancy. It protects women affected by pregnancy or related conditions and must be treated in the same manner as other applicants or employees who are similar in their ability and inability to work. And with the inability to work, they are discussing like disabled employees or employees who have become disabled because of an injury at the job, or they make special accommodations for them. They have to do the same for pregnant women as well. The Pregnancy Discrimination Act also forbids discrimination based on pregnancy when it comes to the aspect of employment, which includes pay, job assignments, promotions, layoffs, training opportunities, access to benefits, time off, medical time off, and a bunch of other conditions related to employment. They have to treat everybody as equal, and I'll explain during one of the cases why this has become a treated as equal thing. An employer cannot single out pregnancy-related conditions for medical clearance procedures that are not required for employees who are similar in their ability or inability to work. They can't test somebody and not test everybody. And that's another thing that also comes up in the interesting court case that I have found. If they must be allowed to work if they're permitted to work. So as long as they can perform their job, you have to let them work. So even if they take a sick day and they come back from that, you can't just say, oh, just stay on leave and make them leave early if they're able to come back and perform and are wanting to work. You must hold a job slot for pregnant women, and the same you would as a disabled employee or employee on family leave. You cannot discriminate against that. Just as if you were to make accommodations for somebody who has been injured because of the job or disabled because of the job, and you give them modified tasks or alternate assignments and like leave purposes, you cannot not let a pregnant woman do the same. So you have to modify their work as well and treat them as the same, and give them alternate assignments and still work for them still work with them if they're able and willing to work. So one of the court studies I found was Silverado versus the Equal Employment Opportunity Commission, and this is actually on the Equal Employment Opportunity Commission's website. So Silverado, which is a network of memory care, at-home care, hospice care, they fired an employee because they said that she was unfit to do the job. They did not try to modify her work or to work with her. And so they fired her because they said that she was unable to do her job because of the pregnancy, because it was preventing her from doing heavy lifting. And they just basically said they didn't have any light work for her to do or alternative work and let her go, and they cannot do that. So the court, they tried to reach a pre-litigation settlement. So they tried not to take it to court. They tried to settle it one-on-one. They weren't having it, so they took it to court, and the U.S. District Judge settled it on January 29th, 2018, that it prohibits future discrimination, prohibits retaliation, so they cannot retaliate against her. They had to pay $80,000 to her, and Silverado must also post notices of the settlement and revise its anti-discrimination and record-keeping policies and report any requests for light-duty work and other job modifications periodically to the Equal Employment Opportunity Commission. So they now have to show them that they are working hard to change their policies and to comply with the Pregnancy Discrimination Act. And they also have to train new managers regarding those rights, obligations, and procedures. They did release a press statement apologizing and thanking. They sent out a press statement apologizing to Burton, which was the woman that was fired, and the Equal Employment Opportunity Commission thanked Silverado even after the settlement. They thanked them for the settlement, but also for keeping up with the work and showing that they are changing. The other case that I have found, this one's very interesting. So obviously she had won that one. This one is interesting because I couldn't really find any lose ones. I mean, majority of the people won, and it wasn't that I couldn't find like a recent lost one. There was somebody who lost, and it was a big case that actually is incorporated into this one and what they're taking into consideration. But basically there was a case that if they are consistent with every pregnant woman and make every pregnant woman abide by the same rules, that they're not being discriminatory, even though they're allowing disabled people or other types of people to bring in doctor's notes and get out of certain things. And then there was another case that said that is discriminatory because pregnant people do have some disability, because I mean they have a bump, a human inside of them, and it's not that it is a lifetime, like they're stuck, like, or they're going to be pregnant for life. It's only for 9 months, and then if they take leave or not. So this one is Thomas versus the Florida Parishes Juvenile Justice Commission. Basically, she worked at this juvenile center for about 10 years. They make you do a performance test, which involves push-ups, a 1.5-mile run, sit-ups, bench press, flexibility test. And she had went to the Human Resources to tell her that she was pregnant and that she was wondering if she could take the 1.5-mile run test during her first trimester or before the scheduled date, so she was able to still comply with them but also try to work with her. And I want to say they denied it. Yes, they did deny it, and they made her run, which caused complications in her pregnancy. It was a blood placenta something, where it made her now a high-risk pregnancy, and they said it was from the long-distance run and the pressure it put on her body. And apparently she didn't meet the time requirement, so she was going to have to do it again. Well, she brought in a note to do light-duty assignments, and she accepted that, and I'm so sorry, I'm reading this while I'm trying to like read everything while I'm talking to you guys. Basically, she had a doctor's note because she was a high-risk pregnancy. They had to give her lightweight assignments, which they could not do, so they made her go on leave, which they are not supposed to do. And she came back 2 weeks later with a different doctor's note after she was on bed rest for a little while, saying that she had no restrictions, but they did not want her running that 1.5-mile run again because they were going to make her redo it. And she had the doctor's note, and normally they allow disabled employees to sit out of the run if they have a doctor's note, which they did not allow for her, and they said that they have never allowed it for a pregnant woman. So basically, they are saying that they're not discriminatory against pregnancy because they treat all pregnant women the same by making them run and not allowing some to sit out because of a doctor's note and some to do this. And basically, Thomas filed a claim with for the Pregnancy Discrimination Act, the Family Medical Leave Act, and the American Disability Act, just because she felt that all of these related to her case. And they did they did a judgment summary, and the judgment summary was granted in some parts and denied in some parts. So it was granted because she did provide efficient evidence of the Pregnancy Discrimination Act, with her not being able to sit out of the run with the doctor's note, but other employees were allowed to do so, and she had an eyewitness that backed her up on her talking to her supervisor and to the human resources, and them both saying, I wouldn't even turn that in because we don't allow that for pregnant women. So the reason why it got denied is it got denied for the American Disability Act, and it got denied for the Family and Medical Leave Act because they did give her efficient leave time. There was nothing about disability except for the fact that they didn't treat her as the same as a disability employee, and the same with the doctor's notes. And but it is the Pregnancy Discrimination Act. So that one is actually still in court right now. That one went on to trial after the judgment summary because they did not feel that deserved the judgment summary. They felt that the court felt as if that needed to be on trial because it was such a strong case because she had the note, and she did try really hard to work around them and work with them, and they were not showing the same courtesy. So that one has not settled out yet, but I just thought that one was really interesting because I couldn't find a lot of cases that have lost the Pregnancy Discrimination Act, and this one she had lost in some part, but she could still win it, she could still lose it, and so that's why I chose this one, because even though it was long and crazy, it was well worth the read, and I think it considers as somewhat of a loss. But thank you for watching. If you did make it all the way through, I'm really sorry for the long video.